Hey, in the house we have Mr. Joe Brusic. He's our Yakima County prosecutor. Morning, Joe. Thanks for coming in. Appreciate it, man.
Thank you very much. As
Yeah.
I always say, it's always an honor and privilege to be on your show. Thank you.
We say the same thing because it is an honor and a privilege to be here in front of Yakima and to have everyone listening as well. Thank you very much. Well, Joe, big ruling coming out of the state Supreme Court yesterday, and coming out of a case out of Spokane, making felony drug possession legal. Or drug possession legal in the state of Washington. So what's going on, Joe? Where'd this come from?
Well, the state statute 6950, 4013, and 4014 essentially were found to violate the due process clause of both the state and federal constitution. Basically, they found it unconstitutional, which means that felony drug possession now has essentially gone by the wayside in the state of Washington. Law enforcement, prosecutors, we cannot and will not prosecute for felony drug possession because it's illegal for us to do so. And it changes so many things within the criminal justice system. And it's not just a simple possession of coke or meth. That's bad enough, obviously. What it does is it's essentially retroactive as well. So it changes, a lot of things that we do consistently and have done for decades here in the criminal justice system of the state of Washington. And for that reason, it's really a massive 5-4 decision by the Supreme Court of the state. And it changes a lot. I mean, it changes the whole game plan. We all know that Oregon essentially decriminalized this through the legislative process. And I know that there was a bill currently in Olympia that was looking at doing exactly that as a sister state to Oregon. And Oregon is politically motivated the way that Washington is in terms of wanting to get rid of these kind of things. But
so does that have to happen now? I mean,
No.
it just doesn't have to happen now because we got a ruling here in our state. Yeah,
That's right.
Yeah.
That's right.
Okay.
I mean, once again, it's akin to, say, the death penalty in the state. The legislature hasn't overturned the death penalty on the books, but essentially we have not only the moratorium by Inslee, but also the Supreme Court of the state of Washington saying that it's unconstitutional, which effectively gets rid of the death penalty here in the state of Washington. This is akin to that decision.
Yeah.
Essentially what it says is that we cannot support charging someone with felony drug possession in the state of Washington now because of this ruling.
All right, let's pull this apart just a little bit. The way it works is our law does not include didn't include a caveat that the person had to know that they had the drugs on them or in their possession, right?
Yeah, when you take criminal law in law school, first year law school, you learn about basically the basic two components of a crime, which is an actus reus and a mens rea. Actus reus, you have to have an act, generally speaking,
Right.
to commit a crime. The second part of that is a mens rea, a mental element. And there are 4 mental elements for crimes here in the state of Washington. And it starts with intentional, knowing, reckless, and negligent. And those are the 4 main mental states that we have to attempt to prove. An example would be that you intend to commit murder, therefore it is murder, right? A classic example would be, a second-degree manslaughter is not murder, it's manslaughter, and you commit an act negligently. There is the mens rea of that crime. In this particular case, they found that the mens rea essentially was a strict liability crime, and so we as the police and the prosecution didn't have to prove a mental element that they knowingly or intentionally possessed a drug.
All right. Well, but let's talk about that. How often did this sort of thing happen? I mean, it seems to me that people every time they would get busted would say, "Well, I didn't know," or it'd be a fairly standard excuse that I don't know whose that is or how it got here.
Well,
that
we
sort of thing.
routinely would see that, Dave, and that's a critical component. Back in 1981, they addressed this issue, and number one, the legislature has addressed this issue and chosen not to change the law. Right, the laws are created by the legislative
Right.
branch. The court, being an activist in this circumstance, has changed the law that the legislature has not done. In 1981, this was addressed, and they created an affirmative defense of unwitting possession. And so once we get past a prima facie case as a prosecution, then they can present evidence to show that the individual that has been charged with that possession unknowingly possessed the drug.
And that's a legitimate defense, which sort of renders the Supreme Court stepping into this as overreach. If there's already a defense on the books, they can't say your due process laws are violated because you guys built in a process. The legislature built a process.
Well, but they saw it obviously from their perspective in a different way than that. They felt that unwitting possession did not resolve the issue and protect an individual charged with a crime in terms of due process. And forcing an affirmative defense, an example was obviously someone like this young lady over in Spokane County, where she said the methamphetamine was in jeans. She didn't know it was in there. The jeans were owned by someone else. She merely possessed them, but didn't possess what was in the contents of that baggie in the pocket of the jeans. That would have been an unwitting, defense, obviously. Tragically, looking at the facts of this case, we routinely would look at certain cases that are investigated by law enforcement and then sent up to us for prosecution. And there are some times where we use our discretion to not bring bad case facts to the forefront, to the court, to prosecute someone. We would choose not to prosecute possibly this case because we would always be fearful of bad law being created, and that's exactly what happened here.
Yeah. It's funny because ever since I started here, when I first started here, one of the cases that we were watching, and it's always kind of been a kind of a joke among us reporters, is that this one case, this lady, make a long story short, this lady got in front of the judge and got some jeans from Goodwill. That's what she said, that had like an ounce of pot in them. And she didn't know, and that was in the court at that time. We all kind of laughed, like, oh, what an excuse that is. But essentially, that's what this case is based on. That kind of, hey, I didn't know I got these jeans.
Well, it's
from
always
my
been
friend,
about,
and the ounce of methamphetamine that it was in the pocket. I didn't need. Not mine, right?
Well, and that's what going to a trial. That's what going and airing the facts out in terms of evidence, both for for the state. Obviously, we have the burden of proving a particular case, so we charge out. The defense does not have the burden of proof to prove anything. But if they choose to, they can present evidence to show that affirmative defense of unwitting possession. Of course, now, as of less than 24 hours ago, that's no longer necessary.
So this means, for instance, offender scores are now you got to go back to say, hey, if you got 20 years because you had a possession on your record, you might get out of jail, you might get a lower sentence, right? Because your offender score is going to change now.
Well, and that's the biggest thing from my perspective as county prosecutor and we collectively as prosecutors through the 39 counties are going to have to deal with. It's not just the possession of, a half a gram of coke that is going to win the day, and that's bad enough. But what it does to the criminal justice system is we have to take this into account, being retroactive, that it changes all those various potential sentences. There's going to be motions to vacate for those that are in prison currently. There's going to be motions to vacate for those that are in jail or for those that have been convicted, where it's affected their employment. It will change the complexion of criminal history and what we count in the offender score that raises those offender scores for subsequent crimes. Once you get rid of those potential crimes in their past criminal history, it could change them very dramatically in terms of the sentences that they either received or that they are now currently serving. Plus, there are washout provisions within our offender score analysis. We have to look at individuals over the course of time that commit criminal offenses and are convicted of them. We look at washouts and whether criminal history can be used or not used to increase the standard range sentences for the offenders.
Sure, yeah.
It's a very complicated system, but now we have to go back collectively and determine those individuals that are going to be coming back to us now, because we know they're existing. I mean, I can guarantee you the prison population right now, there's a lot of people in prison right now that are trying to obtain information, trying to obtain lawyers, trying to, going to start sending motions to all of the 39 offices to deal with these issues. And that's really the biggest imprint. And I can tell you unequivocally, yesterday after this ruling came out, it was talk about the beast quake that we all heard when the Seahawks were playing New Orleans years ago. This one was a seismic rupture of great regard, and for exactly that reason. And so you've got brilliant people across the state in the prosecutor's offices that are now evaluating all the ins and outs and gross misdemeanor versus felony and retroactivity versus prospectively in the future and all these various issues. within the court system of what we're going to do now with all these particular issues that it
Wow.
creates.
All right. Wow. Prosecutor Joe Brusic, thanks for coming in this morning. We appreciate it.
What a headache for you, Joe.
Yeah, wow. You got a boatload of work.
Yeah, it's going to be. It changes a lot of things.